Another motion to compel filed by the Karen Reed defense team, and this one is a doozy. They are asking for a number of different documents, which they claim they already asked Hank Brennan for, but Hank Brennan has not turned over. So included in some of these documents they're asking for is the internal affairs file, as well as any transcripts from any administrative proceedings as it relates to Trooper Michael Proctor's suspension. So that's obviously going to be very important for them to have that file and have that transcript so they can impeach him when he is on the stand. Definitely some good fodder for cross-examination. So let's pull up the motion like we always do. We are not going to read the entire motion. That's what we try not to do on this channel, but we will be jumping around hopefully to the main points of this motion. So starting off, we're just going to jump right ahead to what exactly they are asking the court to compel the production of. So here we go. Defense request number 1. Request for all chain of custody logs, reports, evidence logs, and other documentation regarding how the district attorney's office and or state police came into the possession of each distinct production of video surveillance footage from CPD that has been provided to the defense. Now, we've heard this already a number of times that they keep getting these piecemeals of videos of surveillance from the CPD. So they want the custody logs. They want to know who's been touching what. How is it coming to us in piecemeals? Why isn't it coming in one full package or one video at least? So we've all heard about that. So let's continue down to where the important part is. And here we go. These details, these call logs, not call logs, but these logs about who's touched the video at one point. These details are relevant and necessary to contextualize the raw CPD surveillance video footage and to assess whether the video footage was subject to tampering. That's the ultimate question here, is that why are they keep getting these late disclosures of these videos, some even that came after the trial? Can you believe that? But nevertheless, they want to know, okay, well, we're getting these different clips of videos. Who touched them? Were they subject to any tampering? So that's what the logs will establish. Attorney Brennan indicated via email on November 25th, 2024, that he would request these records, but no records responsive to this request have been produced to date. All right, so that's request number 1, the logs that are relevant to those surveillance videos from the CPD. Defense request number 2, an unredacted copy of MSP report number 26. Well, what is MSP report number 26? Well, here we go. MSP report number 26, going to the highlighted area, associated with the investigation into the death of Sandra Birchmore, produced in NOD number 47. Now, if you're not familiar with the case of Sandra Birchmore, that is a case where, again, you had this cop who appears to have been sleeping with her and having a relationship, and eventually she was killed. And the question was, how did that happen? Well, initially they ruled it as her harming herself. And then after some more investigation, apparently that's not exactly what happened. And exactly, it seems like she was actually murdered. So very, very similar police who worked on that case also worked on the Karen Reed case. So they want to know, they want the unredacted copy of that report number 26. The investigation into the death of Sandra Birchmore has involved many of the material witnesses in Ms. Reed's case, including but not limited to Sergeant Michael Lank, Daniel Whitley, Trooper Michael Dunn, Trooper Zach Clark, Colleen Crawford, Detective Kevin Albert, Lieutenant John Fanning, Trooper Garino, Lieutenant Brian Tully, Deputy District Attorney Lynn Beeland, and District Attorney Michael Morrissey. Given the similar allegations of misconduct by state actors in the Birchmore and Reed cases, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on the credibility of those witnesses in the instant manner. So if these are the same police who are investigating the Karen Reed case and have made certain statements, and then they also investigated the Sandra Birchmore case, and they also made certain statements or reports, and those all turned out to be false, well, then that would definitely be relevant when it comes to how much credibility these people should have in the Karen Reed case. Continuing. In fact, Attorney Brennan replied on November 25th, 2024, that because the Sandra Birchmore case now involves a federal investigation, defense counsel should seek redacted information from the U.S. Attorney's Office. So Hank Brennan said, since this is already in federal investigation, why don't you just seek out these documents, this information, and the important word here is redacted information from the U.S. Attorney's Office. The Commonwealth has possession, custody, or control of relevant reports from the Birchmore investigation that include statements by material witnesses in the Karen Read matter. Many of those statements have since been undermined and discredited, and consequently, they bear on the credibility of those material witnesses and are directly relevant to Ms. Read's case. So here's the question that you should be asking. The question is, okay, let's say the U.S. Attorney's Office has very similar documents, and you got the Commonwealth who has also the documents. So should we bother the Commonwealth, or should we just go to the U.S. Attorney's Office? And the answer is, and it seems like according to under Massachusetts law, that as long as the Commonwealth has possession, custody, or control of those reports, then they have the duty to produce them. You can't just say, well, go to the U.S. Attorney's Office. We're not interested in pressing print on our computers. No. If you've got possession, custody, and control, then you've got to do it. The fact that the U.S. Attorney's Office may have redacted information does not absolve the Commonwealth of their obligation to provide mandatory discovery under Rule 14, right? It's your job. When you are in this case, you got to provide the discovery. Now, let's go to defense request number 3. An unredacted copy of the public record response relating to all email correspondence and communications associated with the Sandra Birchmore investigation. So continuing in the Sandra Birchmore investigation, they want all the correspondence. And they want unredacted copies. So again, just going from a little bit before where I highlighted, in that same November 8th email, defense counsel requested an unredacted copy of the public record response relating to all email correspondence and communications associated with the investigation into Sandra Birchmore, produced in NOD number 47. The Commonwealth has provided defense counsel with a copy of the response to a Public Records Act request concerning all email correspondence and communications associated with the investigation into Sandra Birchmore. So there was a public records request, which of course anyone's allowed to do. You want to do a public records request, you could do that, and you're going to have to they're going to have to turn over some information, which they did. So all Hank Brennan's saying, look, I mean, there's already a public records request, so whatever was turned over in the public records request will turn over to you. Well, is that going to be enough? No. However, the copy that the Commonwealth produced is the same redacted version made available to the members of the public. Now, should we be in the same place? If you're Karen Read and you're fighting for your life, should you be in the same place as the public and get the same access to those records, or you should get more access? You should get even the unredacted reports. Well, that's what exactly the point that they're making here is that since Karen Read is the one that's on trial now, she should have more access than the public. Critically, the interest of the public in obtaining and reviewing these communications is less substantial than that of the defense. The redacted version of the report omits information that is relevant to Ms. Read's case and critical to her defense. I mean, that information that's redacted is very important for Karen Read's case, and thus is insufficient to satisfy the Commonwealth's obligation under Massachusetts liberal discovery rules, right? If this is important for her defense, then she gets access to it, even if it's not access to the public, because the public doesn't need this information. So that can be redacted when you're sending it to the public. But for Karen Read's defense, she should be able to get an unredacted version if that information is relevant to her case, and which would include impeachment material, right? Okay, let's continue. Defense request number 4. An unredacted copy of all reports, communications, handwritten law enforcement notes, and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in this case. So again, more reports, more communications that have to do with the Sandra Birchmore investigation. So again, they say this is what Attorney Elizabeth Little requested. All these reports, communications, handwritten law enforcement notes, etc. Now, the statements that material witnesses in Ms. Read's case made in relation to the Birchmore investigation are relevant for impeachment, as we continue to talk about, and bear on credibility of those witnesses in the instant manner. They are trying to cover up for a cop there, and therefore they falsified police reports, perhaps. Again, we're just, who knows? But whatever they wrote in their reports and whatever investigations they've done, investigations into that harming herself situation, until they actually came to light that no, that's not exactly how she died. Well, the Karen Read should be able to get that stuff. and information. In his November 25th, 2024 email, Attorney Brennan diverged from his previous response. So now, all of a sudden, Hank Brennan is changing his response. His previous response that defense counsel should seek materials of the Birchmore case from the U.S. attorney. So remember, initially, as we read earlier, Hank Brennan's response was, you know what, just get it from the U.S. attorney's office. What are you bothering me for? Now, first, they addressed that earlier, that we're bothering you because you're in this case, and if it's in your possession, custody, and control, you have to turn it over because that's your duty. You can't just say, you know, go to the U.S. attorney's office. It's down the block. Can't do that. So now his response is changing. Attorney Brennan diverged from his previous response that defense counsel should seek materials on the Birchmore case from the U.S. attorney, stating instead that he was not in possession of these materials and referencing an ongoing defense Rule 17 motion. So what do you think they're going to do with that response? Well, their answer is that reply is not responsive to the defense's request. There is no ongoing defense Rule 17 motion. So that's number one. Moreover, despite Attorney Brennan's assertion to the contrary, the Commonwealth is in constructive possession, care, and custody of these records. Don't pretend that you don't have access to these records. You do have access to these records. And if you have access to these records, then guess what? That's considered that you are in the constructive possession, care, and control or custody of those records. And therefore, as the rules in Massachusetts are, under the case law, is that if the Commonwealth is in constructive possession, care, or custody or control of those records, then they have the duty to turn them over. Those witnesses are members of the prosecution team under Massachusetts law by virtue of their participation in the investigating and evaluating the Reed case. So the question really is, okay, who are considered members of the prosecution team? And under Massachusetts law, you are considered a member of the prosecution team if you participated in the investigating and evaluating of the Reed case. And thus, their reports, communications, notes, and other documents are in the constructive possession of the Commonwealth. So don't pretend now that they're not in your possession. If these are people that are part of the prosecution team, these investigators, these detectives, these police officers, if they're considered part of the prosecution team, so even though the Commonwealth say, well, look, we don't have these records on us, yeah, you can go get them. Go get them from your prosecution team. That's the idea there. Okay, moving on. Defense request number 5. And here's where it talks about Trooper Proctor. Requests for all communications, documents, reports, memoranda, recordings of interviews, physical evidence, findings, and or other evidence relating to the internal affairs investigation into Trooper Michael Proctor, including transcripts of the administrative proceedings. So really basically everything that has to do with Trooper Michael Proctor and his suspension. Everything that's to do with that. So this was a request that was made, and this is what the response was. Attorney Brennan has provided defense counsel with a small number of generic letters about the internal affairs investigation, as well as an internal affairs report, which states simply that Trooper Mike Proctor has been suspended. However, the Commonwealth has yet to provide any underlying reports or documents detailing or relating to the substance of the investigation. So we need more reports on that. You can't just give us a little summary. Yeah, he was suspended. Here's the report that says he's suspended. No, there's a lot more to that file. On November 25th, 2024, Attorney Brennan replied to Attorney Little's request by asserting that he is not in possession of these materials other than the documents he has already shared, and that he doesn't believe the Massachusetts State Police shares internal affairs information because, as he understands it, it is protected under Martin. So now the tone is, well, you can't really get these records anyway because it's protected. We can't even turn these over if we wanted to. It's protected under Martin. Well, the defense team says that's not true. Contrary to Attorney Brennan's suggestion, Martin does not hold directly that internal affairs information is protected and is not an absolute bar on the discovery of such materials, even under Rule 14. So no, it's actually not. That's not what Martin stands for. If you go a little bit further, but the Supreme Judicial Court has held that if a prosecutor has possession or control of the records of an investigation by an internal affairs division of a police department with respect to a particular matter, the prosecutor must review that material in response to a Rule 14 motion for the production of exculpatory facts. So it's not just an internal affairs investigation report cannot be turned over and it's protected by Martin. No, if the prosecutor has possession and control or control of those records, then they have a duty to review those records, review those materials, and produce them if there's any sort of exculpatory facts. And obviously, impeachment of the leading investigator of this case would be considered exculpatory. Continuing, Accordingly, the Commonwealth has a discovery obligation to provide any communications and documents that relate to the internal affairs investigation of Trooper Proctor and that are in its possession, custody, or control. So if there's any sort of way that we can consider that this is in the possession, custody, and control of the Commonwealth, well, then they would have a duty to turn over the internal affairs reports and any transcripts and anything that has to do with that could prove exculpatory to Karen Read, which would include impeachment material. Defense request number 6. Request for all material and relevant communications made between members of law enforcement and witnesses in this case, including but not limited to Sergeant Yuri Buchanek and Chris Albert, by email and or cell phone from the inception of this case to the present. So they want now all communications between Sergeant Buchanek and Chris Albert. So beginning January 29, 2022 to the present. Now, why is that? Maybe that's a little too broad. Well, let's see what their argument is, because it's a very interesting argument. So what happened? Well, on August 13th, 2024, the Stoughton District Court received a police report made by Sergeant Yuri Buchanek regarding an instance of alleged witness intimidation. In his report, which appended a screenshot of a text message between Sergeant Buchanek and Chris Albert, Sergeant Buchanek describes an incident that took place on July 10th, 2024, outside Chris Albert's business, the D&E Pizza Shop in Canton. Maybe you've heard of that pizza shop before. Sergeant Buchanek states that he was notified by Chris Albert about an incident that Chris Albert considered to be threatening in nature. Well, let's hear about this incident. Sergeant Buchanek noted that in the text message communications between himself and Chris Albert wrote, "Hey, so I just had 2 women outside my shop taking pictures, which is fine. You're all allowed to take pictures. That's protected. First Amendment." Then one woman lifted her hand and made a gun motion to her head. I watched it and have on video. Sergeant Buchanek responded, "Please email to me," and wrote, "Do you know who those women are?" Chris Albert replied, "No clue. I'll email to you." In his report, Sergeant Buchanek also acknowledged that Chris Albert is one of the Commonwealth's witnesses in a murder case directly referencing Commonwealth versus Karen Read. And the whole idea there was to show that this is all part of witness intimidation. He's one of the witnesses in Commonwealth versus Karen Read, and therefore when these women are pointing a gun to their heads and looking at Chris Albert, that is a form of witness intimidation. The appended text message screenshots between Sergeant Buchanek and Chris Albert, which constitutes material and relevant evidence and is a statement from a witness in this matter, is in the possession, custody, or control of the Commonwealth via Sergeant Buchanek and was improperly withheld from the defense. So this is something that's in your control. Sergeant Buchanek has it since he's part of the prosecution team. So that's considered the possession, custody, and control of the Commonwealth. Right? Anybody that's considered part of the prosecution team would be considered that their materials are in the possession, custody, and control of the Commonwealth. And therefore, you got to turn over those text messages. Sergeant Buchanek is an investigating officer who authored the police report detailing communications with Chris Albert, and he has been identified as a witness in the matter at hand and is directly involved in the prosecution's preparation of this case. Accordingly, Sergeant Buchanek is an active member of the prosecution team under Massachusetts law. Right? So again, this is where it all comes together, because if you are an active member of the prosecution team, then that would be considered that you are that your communications and your materials are in the possession and control of the Commonwealth. Explaining that, and then they cite this case, explaining that the prosecution team includes law enforcement personnel working directly on the case, and his conduct, communications, and possession of evidence are imputed to the Commonwealth for purposes of Rule 14 discovery. Now, what about the fact that they're informal statements? Well, informal statements not intended for court are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation, and should be discoverable to the defense. So yeah, informal statements are discoverable. So just because you're having a text message conversation and it's informal, it is still discoverable. The nature of the July 10th, 2024 exchange implies an ongoing line of communication. So now that just has to do with the communication on that specific date. Why do they want all the communication going back to January 2022? Well, here's the reason. Because the nature of that communication of July 10th, 2024 implies an ongoing line of communication. that necessitates the need for all relevant communication via phone and email between Sergeant Buchanek and Chris Albert since the inception of this case. The informal tone and casual language of the text messages between Sergeant Buchanek and Chris Albert strongly suggest a pre-existing relationship and coordination. So the way that they're talking in this July text message exchange definitely seems that they're very comfortable with each other. They're talking like they're old friends. And therefore, it's very likely that they were talking about this case way before, all the way back to January 2022. This inference is supported by Sergeant Buchanek's police report in which he refers to being notified by Albert about the July 10th, 2024 incident and requests video evidence. The willingness of Chris Albert and Sergeant Buchanek to discuss material information pertaining Mrs. Reed's case via text as evidenced by the July 10th, 2024 exchange suggests that other text messages between the two from the inception of this trial until the present may also contain relevant material and potentially exculpatory information and must be produced. So if they were having communications this entire time about the case, well, then that has to be produced. Now, what's going to be the argument back? Well, the prosecution cannot avoid its discovery obligations by claiming that these communications are covered by the work product doctrine. Meaning, if you're working on a case together to prepare it for trial, then those communications are not discoverable. They're protected under the work product doctrine. So they may argue, well, any communications between Chris Albert and Sergeant Buchanek was because they were anticipating this trial and therefore they were working on their strategy and things like that. And then maybe it's protected. Well, here the defense is arguing, no, it's not going to be protected under the work product doctrine. And they also may make an argument that they were conducted on personal devices or outside formal channels. Now, why not? Why is it not protected by the work product doctrine? So take a look at the footnote here, which I highlighted. The work product doctrine, as referenced in Massachusetts Rule of Criminal Procedure 14A5, exempts from discovery only those materials reflecting the legal research, opinions, theories, or conclusions of the adverse party or his attorney and legal staff. So this is research that you've done on the case. These are your opinions, your strategies, your theories, conclusions. Those are the type of things that are protected. But the doctrine exists to protect, so here's continuing, the doctrine exists to protect the mental processes and strategies of the prosecutor, not factual communications between law enforcement and witnesses. So if it's just factual communications, that's not protected under the work product doctrine. So it's not just all communications about the case is automatically going to be protected under the work product doctrine. And that's what they're arguing here, that there can be a lot of informal just discussions about this case that have nothing to do with strategy, nothing to do with their legal research or opinions or theories. If they are factually based, then they can be turned over as a work. It's not going to be protected under work product. And then what about the informal part that they're talking, let's say, on informal way or their private cell phones? Massachusetts law clearly establishes that communications related to official business, even if conducted on personal devices or accounts, remain subject to public records law and discovery. Meaning, as long as you're talking about official business, as long as you're talking about a case, it doesn't matter if it's on your personal device. You've got a work phone, you got a personal phone. It doesn't matter which one you're using. If you're talking about the case or official business, then you can't say that it's protected because it's your personal conversations. Moving on. G, defense request number 7. Provide copies of all notes and correspondence regarding any testing conducted in this case, along with all research and materials relied upon by the Commonwealth experts in completing their analysis, regardless of whether the witness will be testifying to the information at trial. So we want all of the testing that was conducted by any expert that was retained in this case, any research, any materials, and it doesn't matter whether they're going to be actually testifying or not. We still get that material turned over to us. We have a right for that material. All right, moving on to H. Defense request number 8. Provide all communications between members of the Norfolk County District Attorney's Office and or its law enforcement agents, on the one hand, and all experts retained by the Commonwealth in connection with this case, including dates and substance of phone calls. So this is, again, just communications between the Norfolk County District Attorney's Office and any expert that they were discussing retaining. Defense request number 9. All written communications, including emails and text messages between any member of the Norfolk County District Attorney's Office and or its law enforcement agents and any expert witness the Commonwealth intends to call it at this trial. Okay, so again, communications, emails, text messages between the district attorney's office and any potential expert. And defense request number 10, a legible copy of NDAO 2390-2395. The Commonwealth produced a series of text messages in NDAO found at BP, whatever it is, which are completely illegible. So don't turn over things that are illegible. The defense requests that the Commonwealth immediately produce a legible copy of these communications. So all of these requests based on with included in this motion to compel, that is what the defense is seeking. They want all the Sandra Birchmore stuff. They want the logs, obviously, which are incredibly important. These logs about how these videos are just appearing out of nowhere all of a sudden, and just clips of videos. So they want the logs associated with that to see if there's any tampering with those videos. And very, very importantly is the Michael Proctor stuff. I think that's going to be very interesting for them to get that stuff. Yeah, the text messages between Chris Albert and Sergeant Buchanan. We'll see what happens with that. But the Michael Proctor stuff, I think, is going to be very, very important to be able to get all of those transcripts and copies of any of sort of the documentation that was going on in his proceeding. So that's going to be very important to them. So again, this is going to be another motion that's going to be in the hearing that's probably coming up perhaps maybe February 18th. So we'll see when they take this up. But that is going to be it for now. That's the next motion that we discussed. And of course, there may be even more motions filed as trial continues to get closer. We will be taking a look at them, breaking them down for you, and giving you my analysis on that. So that's going to be it for now. Please, if you haven't yet, subscribe, like, and we will see you next time.